And welcome to Facts or Frauds.
Your Honor, after having an opportunity to consult with Mr. Martin, explain to him what a motion for directed verdict would entail, Mr. Martin would like to address this court with a motion at this time.
I'm going to ask the jury to stand up. All rise. I'm going to ask the jury to follow Officer Rose into the hallway and have a seat in the benches out there so we can come back. All right, so the jury is out of the presence and the prosecution has rested. Are there any motions?
Your Honor, just going to make a record real quick. So Mr. Martin has been advised by co-counsel that legal precedent is not going to be put forth through direct or cross-examined testimony, that this is the proper avenue and the proper time to make his legal arguments. And so he understands that, again, I shouldn't say what he understands. I've advised him that that's what this motion is for. This is the proper venue, and that's where we're at. Mr. Martin, you'd like to make your
Mr. Martin, you're making a motion for a directed verdict, is that correct?
Yep.
Okay.
Mr. Martin, I've advised him that his burden starts with people have not, or his argument starts with the people have not met their burden, and he's now to explain to the court what legal authority he has that supports that based on what we've heard today.
Very good. Mr. Martin, a very, very sound foundation has been laid for you by co-counsel. Please proceed.
As the testimony, the board admitted he did not know whether what I was traveling went 30 miles an hour or not, up to 30 miles an hour or more, and does not exceed 100 cc. He admitted that he did not know that. That is both of them elements. Actually, only takes one of the elements, but he admitted to both of them elements. He didn't know whether they exist. Both of them elements are necessary to exist to meet the definition of a moped under MCL 257.32b, which makes it clear that is the definition of a moped. One, it must go at least 30 miles an hour. Two, does not exceed 100 cc. He doesn't know, as he admitted, don't have evidence. So there's no evidence that it was even a moped. Therefore, the charge must be dismissed on that alone. And I have more.
All right, so let's do this for the sake of appellate representation and argumentation. You say you have more. So let me make rulings as to each of those so that the appellate court can take one, do what they want. Because, like, for example, if they overturn me on that first one, there's no point to go and do anything with the rest. So with regard to the fact that you say that this case should be dismissed because the evidence did not show that it was a moped. The evidence clearly showed that it was a moped because, one, Officer Borg said he was driving a moped. Officer Borg is a person who I don't know any person who couldn't recognize a moped. Now you're talking about what is the legal definition of a moped that you can find in some statute. Sure, I get that. Whatever. Well, there's some statute that says things that just if you can do 30 miles an hour and you have this many cc's or whatever, we'll call it a moped. But I also just need testimony. All I need is testimony from a competent individual who has knowledge of the same, of what a moped is. He was asked, did you recognize it? Yeah, it's just a common moped as you would commonly know or refer to as a moped. So for that reason, that specific motion to dismiss, a motion for directed verdict, is denied. On to your next one.
I'd like to say some response, but I don't know.
And you'll have that opportunity to do so on appeal, sir.
All right, well, next.
If I may just address it briefly.
I'm sorry.
Was it all right?
I ruled that
okay, fine.
It was clear testimony by Officer Borg that he recognized it as a moped.
And the statute requires that he's operating a motor vehicle. The definition for a moped only applies to whether or not you could get a restricted license.
Sure. And he's clearly not 15 to 19 years old, so it doesn't matter.
It was every vehicle that's
it was a motor vehicle, absolutely. Yeah. And there was testimony that it was on the road. It doesn't matter how short or how long that it does. It's for any brief time at all. If you're operating it operating it on a roadway, it doesn't matter if it's for a millisecond. And so for that reason, as far as the moped goes, a moped is clearly, you said you drove it off. Like you said it in your opening statement, you said it when you were testifying.
It's a commercial.
So it definitely wasn't a wooden, like one of those rocking horses or something like that. It was something that actually moves when you make it try to move and you push buttons or do something and it goes. So it was obviously a motor vehicle because you weren't pedaling it, you weren't flintstoning it, and you weren't rocking. So it was motorized and it was on the road. So your motion for directed verdict with regard to the definition that you're trying to come up with about a moped is denied. Your next reason for directed verdict, sir, is?
People have not met their burden because, as the U.S. Supreme Court said in Packard versus Banton, page 259, 44 Supreme Court Reporter, page 259. I have copies here to give I'll get one of these prosecutor. The Supreme Court, their quote, you can tell it's right out of the law book, nothing I typed up on that. All right, the streets belong to the public and are primarily for the use of the public in the ordinary way. Their use for the purposes of gain is special and extraordinary, and generally at least may be prohibited or conditioned as the legislature deems proper. So, as they're saying, the legislature can regulate the use of the roads when it's being used for profit. As Borg admitted, he had no evidence that I was carrying passenger property for profit. And as the Supreme Court case right here demonstrates, I have the right to use the roads as long as it's not for profit. Since I wasn't doing it, I was not driving a motor vehicle. And also, I'm not done with that argument, as an extension of part of that argument. All right, now the state statutes mention driving without a motor vehicle, use them terms, which is not a current. They don't give a real definition. I know we're doing that 20 years. I don't know everything, but okay, where is it at? I got it over there. Okay, and I got copies here so you can see this right off the law book of Slaven and prosecutor. Okay, it's 18 U.S.C. section 31, subsection 6 and 10.
First off, let me make a ruling on your Packard versus Batten motion. So you, under Packard versus Batten, they make a quote and there's a citation to it. It's cited in amongst other cases as well. State versus Johnson, 243 P 1073. There's Cummings versus Holmes at 155 P 171. Packard versus Batten at 44. Supreme Court 256. There's Hadfield versus London at 98. Washington 516. All of them quote to the same quote that originally comes from Hillhouse versus the United States, that says a citizen has a right to travel upon the public highways and to transport his property thereon. It doesn't say you can do it without a license. It just says that you have a right to travel, yes. But it doesn't mean, just because you have a right to travel doesn't mean that there is not a state's right under the health, safety, and welfare regulations to regulate those industries that have dangerous things. You can't drive a helicopter around. You can't drive a spaceship around. You can't, even a boat. Anything that could possibly run somebody over or kill somebody, you need to have a license. So you keep saying it. And all these people on the internet like to keep quoting to it. And it's not what it means. Read the whole case. Yes, you can have a right to travel, but the state has a right to license you. So for that reason, the Banton, sir, don't approach my bench. Don't ever approach my bench.
Excuse me. Well, thought I could do it.
Listen, trust me, you can give it to me all you want. I've read this matter 100 times. I've read every single one of those cases that I just quoted to you. Why? Because I'm fascinated by it. I too am a pure constitutionalist, and I almost want you to be right, but you're not. You can't just travel any way you want to. You can't do it in certain in vehicles on public roads without a license. So for that, your Packard versus Banton, that's a misstatement of what the actual state of the law is. And yes, you do need a license. The Supreme Court of the United States has never said that you don't need a license. That federal statute has nothing to do with you driving on a road here in Michigan.
When I approach that, I show you this, we can see word for word, they say what I just said
I
about.
want to hand it to Mr. Legislator. Mr. Hadley can give it to you.
The legislature only regulates it when it's being used for profit. They said that word for word. They didn't say nothing about only on.
Yes, I've read
You're
this
saying they
in
didn't
Packard.
say that.
So the streets belong to the public and are primarily for the use of the public's ordinary way. Their use for the purposes of gain is special and extraordinary, and generally at least may be prohibited or conditioned as the legislature deems proper. You're literally proving my point. It literally says may be prohibited or conditioned as the legislature
When it's
deems
being used for
proper.
gain.
No, as it means, it doesn't say that. It doesn't do it at all. Under the 14th Amendment, Mr. Hadley, I'm going to give you this.
Thank you, Your Honor.
That's why I read it into the record, because you're literally proving my point for me, sir.
Mr. Martin, your motion has been heard. The judge has made a legal finding on this.
Yep.
The court reporter.
Let's move on. Let's move on to the next one. Your
Okay,
USC.
now, 18 USC, federal statute made by Congress defines a motor vehicle different than the state statute.
Hold on. This is my court recorder's.
I have the copy too, I can give it to you.
My court recorder is making a recording. I want to make sure that, because you start to speak a little, you get a little excited, and you start to mumble and speak fast. I want to make sure that everybody can hear you and that she can make a proper record. So you were about to tell me that 18 USC, what was the next part of the
Section 18 USC section 31, subsection 6 and 10. Both of those define a motor vehicle as one only being used to carry passengers or property, which the evidence shows, and as he admitted, I was not doing. He doesn't have no evidence to say I was doing. Therefore, I wasn't driving while revoked. Now, under Article 6 of the U.S. Constitution.
Okay, can you see again? You're mumbling. And I
Okay,
can't.
well, I'm mumbling.
So motor vehicle, the term motor vehicle, because I'll read it right.
Okay, yeah, go ahead, read the term motor
So
vehicle.
it says motor vehicle. The term motor vehicle, this is literally ready. The term motor vehicle means every description of carriage or other contrivance propelled or drawn by mechanical power and used for commercial purposes on highways in the transportation of passengers and property, or property and cargo. Okay? So,
Now, I'm gonna cut you up on add on.
sure.
Okay.
Now let's go down to
six.
let's go down to paragraph 10
All right.
and get the definition of used for commercial purposes. The term used for commercial purposes means the carriage of persons or property for any fare, fee, rate, charge, or other consideration, or directly and indirectly in connection with any business or other undertaking intended for profit. But you're talking about this section 31, and what is the whole section 31 about?
Now, well,
Exactly.
you just said it's about the definition of motor vehicle. Now, Article 6 of the Constitution, point out, makes this, because Article 6 makes it clear, laws of the United States, which means federal statutes such as this, along with treaties and the U.S. Constitution, is supreme law of the land. So this definition is supreme over the state law definition, which doesn't say this. This is why I'm not guilty, because I wasn't driving a motor vehicle.
May I address that, Your Honor?
Please.
Yeah, so there is nothing that I'm aware of in the United States that I'm at least aware of that citizens of the United States or natural people or human beings can obtain a federal driver's license. The regulation of roads and driver's licenses has been left to the states with respect to the issuance of licenses and motor vehicle codes to be enforced locally and in the states. There are going to be a number of definitions for the word person, for the word corporation, for the word motor vehicle as it's applicable to any particular statute. And if you pick a federal statute that is applicable to motor carriers and it's defining motor vehicles and what's subject to those regulations, then that may be the definition. Sure. However, federal law only preempts local and state law where it takes up the space. And the federal government has not taken up a space with the issuance of driver's licenses to the citizens of the particular states. That's why you have different rules. Some you can get a permit at 15, some at 16, sometimes you get a restricted license, sometimes all those things. It's different in every state. That's why.
Mr. Martin?
Object against
Mr. Martin?
Article 6.
Mr. Martin?
The Supreme Law.
Mr. Martin? Everything that Mr. Greco just stated is correct, and it's the reason why I'm denying your motion. Additionally, what you need to do is you need to go to you need to go to 18 USC, go to chapter 2, before you get to section 31. Because what it says, and actually what you need to do is you can actually go right to part 1, because let me give you the total thing so you can read the full statutory history. It's 18 USC, so that's Title 18, Part 1. Part 1 is all the crimes. These are all federal crimes. Every federal crime that you can think of, you can find in Section 18. So now we go to Chapter 2. Chapter 2 is aircrafts and motor vehicles. So every crime that you could possibly commit using an aircraft or a motor vehicle, a federal crime, is found in 18 USC Chapter 1, Part 2, and then you go to these sections. The first section is 31, and that's where you find your definition. So for everything we're about to say, for every crime we're about to talk about, here's the definition of an aircraft, here's the definition of a vehicle. And so you're going to find things like fraud involving aircrafts, violence against international airports, drive-by shootings. These are all things that the federal government has made a crime about, and they're defining just for those statutes that thing. The problem is, everybody on the internet who wants to be like, I got a right to travel, look at this, look what I found this, let's take this one statute out of context and just stand on it like it's Plymouth Rock. No, that's the definition for all the crimes that are underneath it. 31, section 31 is just a defining statute that defines all the terms that you're going to find in 31, 32, 33, and all the way down of all the crimes that federally they have, commercial vehicles that are required to stop for inspections, unsafe operation of an unmanned aircraft, aiming a laser pointer at an aircraft, all these different things that are crimes under federal law. That section 31 is only the definition for those, nothing else. It's not superseding state law. Why? Because under the 10th Amendment, anything that's not stated specifically in the Constitution reverts back to the states and its peoples. And Congress has made, like Mr. Greco said, has made no effort to say, look, we're going to create a national driver's license so you can just come and go anywhere you want. You want to know why they didn't make a national driver's license?
I think
Because of Article
4, the privileges and immunities. When I go to Ohio, they can't arrest me for not having a license because I have a Michigan license. And when Ohio people come up here, we can't arrest them because they don't have a Michigan driver's license. Under the privileges and immunities, there's already a constitutional provision that allows for licensing, whether it's your license to carry a firearm, or whether it's your concealed weapons permit, or whether it's your, like hunting licenses and things like that. Sure, you got to go right to those states. Why? Because that's their state. They still have sovereign powers. They still have their own constitutions. So your definition from 18 USC section 31, you're skipping the two parts that are in between that. And those two parts that are in between that are Part 1, Chapter 2, which tells you exactly what 31 is doing. Okay? So for that reason, it's denied. You can take it up on appeal if you'd like. Your next reason for directed verdict?
Yes, no, this is another case, Pickerton versus Verver, Michigan Supreme Court, decided in 1889. And I have the pages here to give to you, so you can show the pages.
I don't need you to give me any copies of anything, sir.
584, quote unquote, they say, this is the ball in the right to travel, personal liberty, which is guaranteed to every citizen under our Constitution and laws, consists of the right of locomotion, right, not privilege, okay, to go where one pleases and when.
Sure, and you just can't do it by car tonight.
They never said it, so.
You just can't do it by car.
They did not say that.
You can walk yourself anywhere you want to, when and how you want to do it. You can walk backwards, you can skip,
You can do somersaults, you can cartwheel,
Yeah,
but
so
you can't use a car.
You can use a
So that
car,
one's
motorcycle. They're saying
That one's denied. Sir, you're not gonna get argumentative with me. I've already told you that that's denied. There's no, that's not a legal argument. I've admitted it. Yes, you have a right to travel. You can't do it by unlicensed driving of a vehicle.
Well, can I finish reading the Michigan Supreme Court code then?
No.
Like halfway through.
Because that one's denied. For the same reasons that I've already denied the
Looks like I
same.
got other cases based on the same laws.
And it's gonna be repetitive evidence, and you're not gonna just keep coming up with a different case that says the same thing, that says you have a right to travel, because I admit, yes, you have a right to travel. You just can't do it by any sort of mechanical means that they need to license, whether it's by boat, or automobile, or helicopter, or spacecraft, or whatever the Jetsons thing would be. Any of those things, I'm sure you're gonna need a regulation. Why? Because those things can kill people if they don't do it right. Walking, I don't know of anybody who's walked into somebody else and they ended up dying because they collided. So, pretty safe with that one. Riding a bike, yeah, same thing. So those methods, sure.
That's much correct.
Doesn't matter.
Right, so it's about people's burdens. I think again, if you've got something that is a new argument about what they didn't do, if it's not, you've already made your appellate record. We've got a jury, and then you can do that with something.
Oh, I do want to, since you've been, not gonna.
So I think no.
So also, based on, I'm gonna make another motion now to, based on you denying all my motions in violation of my constitutional rights.
That's incorrect, sir.
Well, this is, okay, I'm just stating my basis anyways.
I'm merely making rulings based on the law, and so I'm not violating your constitutional right. Just because you don't get your way doesn't mean that you get your violation. This isn't kindergarten. This isn't kindergarten court. That's not how that works. We're not going to do temper tantrums with legal, frivolous things and stomp our legal feet with a bunch of arguments that have no relevance nor substance at all. And then you just keep making it and keep making it over and over until I get browbeaten enough where I go, oh, you know what, Mr. Martin, I'm just going to dismiss the case. How about that? No, that's not going to happen. It has to be something. If you had something that was relevant, substantive, and right on point, I'd dismiss your case in a heartbeat because I've done it before with other cases. But you're not just going to keep bringing up the same, this case says I have a right to travel. True, it does. This case has a right to travel. Sure, it does. But that doesn't mean you can do it by not having a driver's license and operating any kind of motor vehicle. So do you have any other,
Different arguments here. Or
do you have any different argument that's not, I have a right to travel?
Yeah, this one, okay, I'm going to dismiss this case based on Declaration of Independence of 1776.
You already did that. That was the second motion you made when you first started making motions. Next.
Well,
I think you may have reshuffled your paperwork, so.
Yeah.
Going back up to the top.
I'm gonna move that you be disqualified from the case for denying my motions. I'm alleging that it was done in violation of the Constitution. Therefore, you should be recused from the case and dismissed.
Okay. Pursuant to Michigan Code Rule 2.003, any motions, I think it's C, any motions to disqualify are heard by the judge who's presiding, which is me, and I'm denying that motion.
Therefore,
That might be
request that you send it.
citation, but I think it is.
I request that you send this motion that you're denying to dismiss yourself to the state court administrator, which is supposed to be done by the court rules.
I did.
Have the state court administrator deal with the matter.
MCR 2.003, I'm thinking this is for disqualification, and it's heard by the judge that's presiding it, and I am denying that motion. You can take that up on appeal as well.
I think that's all the legal arguments I have.
All right, so
I think as soon as I sit down and go through the paper.
Your Honor, on the civil
closing
infraction,
argument?
yeah, I was gonna say real quick before I pull in on the civil infraction, I can keep it, I can do
Well,
it.
let's just do the civil infractions right now while they're already out.
Yeah.
So yeah.
So I think the testimony clearly established that he was operating with no proof of insurance. In fact, he had no insurance. So the evidence of that. With regard to the flat tire, it looks like he did have a flat tire. With regard to the
He said it in his opening statement. He even said to the jury, "Come on, really? If you're not picking at me, why are you coming at me about a flat tire?"
And he testified toward the end that he did not think during his sworn testimony, he indicated that he did not think he was operable toward the end because it was flat.
Yeah. So, and the report, when he ran the report on the computer, it came up that there's no insurance. So, anything you want to say about that no insurance or the?
Yeah, the MCL, looking for the MCL right now. MCL
on the
clearly
insurance?
makes it clear that.
Sir, if you take one more step, I swear I'll come over this bench.
So Mr. Greco made the argument, the closing yes.
Yeah, okay, so, no insurance is required for the MCL I'm looking at right now, for a moped specifically, it is not required of a
No,
moped.
there isn't at all. But once you drive a motor vehicle, once you take it onto the road, because I also teach no-fault law at the law school. So once you take any motor vehicle onto the road, it has to be compliant with everything else is on the road. So that means you have to have insurance.
MCL.
The reason, and I can tell you the great case. The best case about it is a kid who's driving his moped on the road and he gets hit, and then his mom makes a claim with the insurance company and he gets denied. You want to know why? Because he's an uninsured motor vehiclist. As soon as he takes that moped on the road, boom. Same thing with people who take golf carts on the road. Boom. You better have insurance on your golf cart, because if you don't have insurance, like an actual, like the State Farm type motor insurance, as soon as it goes on the road, you're operating a vehicle with no insurance on the road. So
I have nothing further to
Yeah, so that's no, the MCL right here, clearly says.
sir, you can take me up on appeal, but I just gave you my ruling of why that does not apply.
Your Honor, if I may, on the other civil infraction, I'm going to make a straight preponderance argument. I would state I understand that there was.
I'm going to dismiss the tire one because I don't know what the tire looked like, and I don't know what the tire. Because if the tire can move, then is it defective? If I can drive on it.
That's my argument.
If I can drive on it, it's obviously not defective, because defective means it doesn't work. If I go to use my washing machine and I put clothes in it, and all of a sudden I push the button and all I hear is nothing moving, well, that's a defective washing machine. But if it washes my clothes, how defective is it? Even if it doesn't, like in a poor manner. So maybe it's a poor manner type of tire, but is it a defective tire? A defective tire won't roll. So
That's our argument.
dismissed.
Thank you.
So it's responsible on the no proof, dismissed on the tire.
And let's get Mr. Martin, let's get the jury back in here again.
So I do find you responsible on the no proof of insurance. That's $165 in fines and costs. I'm dismissing your defective tire citation.
Your Honor, Officer Borg, I think we're done with the testimony and everything, so Officer Borg does have to leave.
Officer Borg is free to leave if he'd like to leave, yes.
Thank you, Your Honor. Thank you.
Have a good day. All right, so Mr. Martin, your closing argument.
There's a lot of paperwork to sign. Okay, so one, this court doesn't have, the so-called court doesn't have jurisdiction for this matter because Article 3, Section 2 of the U.S. Constitution.
Mr. Martin, I've already made a ruling on that. If you're going to give your closing argument as to the facts that were presented, please do that. If you're going to give some sort of legal argument that you've already given before, and I've already made a ruling on, that's not.
I understand. How am I going to make a closing argument? I can't cite the law. The closing argument deals with.
Your closing argument is about the facts that you presented. You presented facts. You got on the witness stand to talk about your facts, not any sort of legal arguments that have already been ruled on by me.
I don't understand.
You're more than welcome to have Mr. Hadley do your closing argument if you'd like.
I understand the defendant law 20 years is allowed to make.
My understanding is that closing arguments are about the facts that were presented at trial, and you can talk about the facts that were presented at the trial and how that plays into your theory of the case. If you want to make motions to dismiss and things like that, which you've already made and denied, you're not going to just rehash those in front of the jury because that's not.
I'm not making motions, I'm making a legal argument.
You're not. It's not a legal argument. You know what, sir? Sit down. Mr. Hadley, you're going to do closing argument.
Ladies and gentlemen of the jury, thank you very much for your patience today. I know when you watch these on trial, TV trials, it's a lot more exciting. There's not this weird stop starts. So thank you, sincerely. I know this has been an afternoon. Quite simply put, the people bear the burden of proof. You heard evidence today, and as the judge will instruct you, and it has instructed you, this is solely the people's burden. They must prove to you beyond a reasonable doubt, based on the actual evidence that's placed on the record today, that this individual violated the statute driving on a license revoked. Now, we can recap what we've heard today. We heard from the officer who testified more or less to his recollection of what happened. You can all make arguments that memories aren't perfect. You can speculate as to what actually happened that day. I mean, we do have the officer's testimony. He testified as to his recollection of what happened. You heard from Mr. Martin, and we had our two witnesses today. He told you what had happened. Now, you heard no evidence that Mr. Martin injured, hurt anyone, ran a red light, speeded anything. It was, as he had stated on the stand, a victimless type of crime. So while Mr. Martin has, again, made some very interesting legal arguments to you today, what we really need to look at is, again, did the people meet their burden of proof? You know, was there enough evidence put before you today for you to make that decision? As co-counsel, the defendant, my position to you today is they haven't. It's a very high burden that they must hit. They have not hit that based on what they presented. So we'd ask that you return a guilty or a not guilty verdict based on what you've actually seen today. So I really, again, sincerely thank you for keeping an open mind as you go through this. Really, at the end of the day, I know that this is an individual who believes dearly in the arguments that he has made and the statements and the position that he's taken. And with that being said, this is a state that people I have nothing further. Just thank you for your time.
Mr. Griffin.
Yeah, just briefly, I think the testimony of both Officer Ward and the defendant, Mr. Martin, we have met the burden. They violated the law that day. I'm not going to go through it again. We can use the officer's testimony or Mr. Martin's own admissions and testimony regarding what happened that day and how he violated the law. He just disagrees with it. But as the jury, you need to apply the law to the facts as the judge is instructed. Thank you.
This is the case of 231510, People versus Eric Martin. The jury has deliberated and is now back. Is there a foreman?
Sir.
Mr. Foreman, has the jury reached a verdict?
Yes, sir.
In the case of the people of the city of Taylor versus Eric Martin on the charge of driving on a suspended revoked license, how does the jury find?
We found the defendant guilty, sir.
All right. And juror number one, juror number one, is that your verdict?
Yes.
Juror number two, is that your verdict?
Yes.
Juror number three was dismissed. Juror number four, was that your verdict?
Yes.
Juror number five, was that your verdict?
Yes, sir.
Juror number six, was that your verdict?
Yes.
Juror number seven, was that your verdict?
Yes.
Let the record reflect, if you're polling the jurors individually, that each of them has come to the same unanimous decision of guilty as to the driving on a revoked license. I'd like to thank and dismiss the jurors. All rise. Let the record also reflect that I'm going to place Exhibit 1, Plaintiff's People's 1, into the court file. We're going to set this for a sentencing date with a PSI, or we're moving for immediate sentencing today.
PSS. Gives the judge a sense.
Judge, any sense of violation of the slavery or slavery.
Says
All this violation of the slavery.
Would you like to be sentenced to life? I don't agree to no sentence, that's not the question.
All right, so I'll set it for a sentencing date then. And I'm going to refer to a pre-sentence investigation report. And you'll be notified by the probation department, sir, to come in for the pre-sentence investigation report. And then you'll be able to read the report before the day of sentencing. You'll be able to go over that with Mr. Hadley. And we'll see everybody at that time.
I move to stay it based on appealing the issue. Are we appealing it?
I can't give you any legal advice, sir.
I'm moving to stay it. Stay the sentence.
Sure.
I'll just say the sentence.
Right.
I just did. So
No, just the keys. No, we should get the file and get served. Closing counsel. Closing counsel has a right to be served.
I request to be appointed appointment of counsel Slaven to appeal these issues. Well, everything's been denied in this court. Is the record still on?
No, we're off the record.
Okay, let's go back on the record.
You're gonna get a PSI.
All right,
The case isn't done
I want to
yet.
be appointed appellant
The
counsel
case,
to appeal
the
the
case,
issues.
well, there's no appeal yet, because the case isn't done yet. You haven't been
No, I said
sentenced.
we're to appeal the issues that.
Oh, you haven't been sentenced yet. Then after the sentencing, then the case is done, then you go to appeal.
I still have a right to interlocutory appeal the denials of my constitutional on my motions. if they're denied.
I can't give you any legal advice, sir. All I'm telling you is that you better show up for the PSI and for the sentencing date. Then you can do whatever you want on appeal. All right, this concludes this matter.
But more, oh yeah, much more than this. I did it my, anybody out there from Walla Walla, Washington? Anybody out there got a birthday tonight? Well, there were times, oh yeah, I've had a few when I've been off, oh yeah, more than I could chew. But through it all, when there was dope, oh yeah, I ate it up and spat it out.
I don't remember how the rest of it goes.
And thanks for hanging out with us on Facts or Frauds. Make sure you hit the thumbs up button, you're subscribed, and ring that bell for notifications so next time I premiere a video you can be in a live chat with everyone else and leave a comment in the comment section, tell me what you think. And a huge thank you to all of our Facts or Frauds channel members. And if you're still hanging out, thank you. I appreciate you all. Make sure you hit that thumbs up button, you're subscribed, and leave a comment in the comment section. Tell me what you think. Until next time, I'll see you soon.